Our discussion, and you can get in touch with us on 22422, which is our SMS line. Just moments ago, the second petition was filed at the Supreme Court. Our Francis Goshuri is standing by, and we'll be going to him very shortly to get to details on this latest petition that has been filed by Njonjomu and Khalifa. They're arguing on various grounds, including the fact that there was an atmosphere of intimidation, that there should have been fresh nominations, and that the withdrawal of NASA leader Raila Odinga from the presidential contest should have triggered a fresh election. Francis will be giving us details shortly, but first let me introduce my guests to you. In studio right next to me is Dr. Lutalala Mukwana, and next to him is James Mambole. They're both advocates of the court, and I thank you both for being with us this evening.
Thank you.
I want to start with you, Daktari, and talk about the Mwao petition in particular. This one has various grounds, starting with the fact that they believe there should have been a fresh election that is premised on the basis of a fresh nomination, and we're seeing that similar theme coming up in the second petition. Just walk us back to the arguments that there were surrounding whether it was necessary to have a fresh election and the definition of that term.
Thanks, Anne, for your invite. I think that the crux of Honorable Mwao's application is that when the Supreme Court made an order for fresh elections, the term fresh elections ought to have been read literally. It was to be a fresh election. And according to his pleadings, he says, if you go to the Elections Act, fresh elections entail nominations of candidates. And that if candidates are not nominated, therefore it cannot be a fresh election, and therefore any other action proceeding after that is null and void. And therefore what Honorable Haron Mwao is saying is that the IEBC erred by saying that once the court ordered a fresh election, they only proceeded with the candidates who had participated. In fact, on the part of the IBC, they proceeded with only two, Honorable Raila Odinga and Honorable Uhuru Kenyatta. It was only much later when a court applied to court that he was allowed, and thereafter, of course, IBC allowed everybody else who had participated. So the long and short of Haron Mwao's application is that the court ordered for a fresh election. It ought to have been fresh in the strict sense of the word, including nominations for fresh candidates. That did not happen, therefore he finds fault with that entire election process.
All right, so that is basically the sum of the Mwao petition. James, just give us a brief on this second petition that has now been filed by Njonjomu and Khalifa. What are the key grounds that stick out to you? They've talked about an atmosphere of intimidation, meaning that it wasn't a free and fair process. They've also talked about the withdrawal of the NASA presidential candidate from the race that would have required IEBC to go back and conduct, fresh nominations and go through that process all over again. Can you explain the rationale for that?
Thanks, Anne. Two important things. The first one is the question of whether the withdrawal of Raila Odinga from that election therefore meant that we were in a situation in which the country could not have proceeded into another election. That picks up from where Dr. Lutalala has left it, which is basically an interpretation of what a fresh election would mean under Article 140, sub-Article 3 of the Constitution. And, the Supreme Court did attempt at giving an explanation really as to what that fresh election would entail. And my hunch is that IEBC got it wrong right from the very beginning by taking just President Uhuru Kenyatta and Raila Odinga to the ballot, or gazetting them in the first place. What they should have done at that early beginning was to gazette the three candidates, Raila Odinga, Uhuru Kenyatta and Ekuru Aukot. As a result of which, therefore, the logical conclusion would be that even if Raila Odinga had withdrawn from that particular election, then he would have been left with the other candidate, who was Ekuru Aukot, to run with Uhuru Kenyatta. But the important thing that we should also note there is this, that at that particular time, that was the guiding principle, the 2013 decision of the Supreme Court. Now, much later, we see the High Court giving an interpretation. Remember, Ekuru Aukot went to the Supreme Court to ask for a clarification on whether he was entitled to run in the presidential election. And the the High Court, the Supreme Court stated very clearly that, you see, we do not have jurisdiction to deal with a matter like that, because the home of constitutional interpretation is first and foremost the High Court. And so he went to the High Court, and the High Court gave what I believe is the correct interpretation, that all candidates, including any other candidates who would have wanted to run in that election, were actually amenable to run. Only that there was not sufficient time to conduct a nomination for the purposes of the 26th October election. So that is where I think we would leave it. Now, in relation to the Njonjo Mue petition, there's something that is extremely important, and I think this is the point they are trying to make, alongside the question of nomination. They are also trying to say that this election should be impeached on the basis that it did not fulfill the requirements of Article 138, sub-Article 8 of the Constitution, which requires that an election is conducted throughout the 290 constituencies. Now, that is a question that I'm sure is seized of the courts. Many lawyers have argued this way or the other, depending on which political divide they lean to. But however, my own interpretation of that would be the best place to find the solution to that particular question would be Section 55, capital B of the Elections Act, which provides for the process that the IEBC can follow if, for instance, a certain environment or a certain section of the country becomes impossible insofar as administering an election is concerned.
Right.
And so therefore, if you followed that particular section, it would lead you to several parts, and article and section 3 of that particular section does say that, for instance, if it is impossible for an election to be conducted because there is likely to be a breach of the peace in subsection 1, then under subsection 3, the IEBC would consider the return of all the other results which have been brought in, and if in its own opinion, or if it's in consideration, it is not possible to alter the result of that election by looking at those areas that have not voted, then it can declare the result.
Fair enough. And just to a lot of viewers, the pictures that you're seeing are live. We've seen lawyer Harun Wau leading that brigade of lawyers to the courts. We understand that just minutes ago, they had headed to the bank to deposit the requisite 1.5 million shilling fee, for such a petition to go ahead. I just want to talk about a little bit of the practicality of having, these two petitions before the court, Dr. Mukwana. We saw in the two petitions that have previously been before the Supreme Court that even handling just one ends up being, this incredibly difficult process, to the extent that there were recommendations that this time period should be extended. And now here we have two. Do you see a situation where the court may need to have these two petitions collapsed in order to be able to deal with them within the time that is provided in law?
I think so, Anne, and you got it right, because purely for purpose of administrative convenience, and you also got it right when you talk about practicality. Look, 14 days is not sufficient for the justices to traverse the entire breadth and width of those applications. So I foresee a situation where they will, during the pre-trial conference, they'll have a chance to look at the issues that have been raised by both applications. And if there are areas that have convergence, areas that really are talking about matters, issues that can be addressed in the same forum and in the same breadth, then I think, yes, those issues ought to be collapsed and discussed at the same time, so that the court then is able to dispense with issues of commonality, and the issues that stand out as separate then are dealt with differently. That is purely for administrative convenience, and I think that will be the position. All
right, James, again, no one is challenging the numbers that the president got, and it appears from just the cover reading of this that again nobody is imputing improper motive on the president-elect in the way that this was handled. What are your thoughts on that, and where does that place IEBC once again?
I think for the simple reason that you see this was a very unique election. The major political divide against Uhuru Kenyatta had pulled out, and so a lot of what you could have expected in terms of observation and monitoring of that particular election did not actually happen. So that being the case, it is not possible for anyone who did not participate in the election probably to raise serious questions on the substance of the actual election as it took place. But you have had heard the court say time and again that the election is a process, and any part of the process can be challenged. You can challenge the transmission. You could decide to challenge the processes preceding the election, and which is what I think the petitioners have decided to do. So what I've seen is the common theme really running through these two petitions is the question of nominations, and to a really large extent the fact that the fact that the election was not conducted in all 290 constituencies. So these are purely questions of interpretation of Section 138 of the Constitution. It also gives the court an opportunity to look at what the petitioners have to say in respect to, or in respect of the interpretation of the Supreme Court in as far as what a fresh election would mean as pitted against the Justice Mativo ruling or decision on what a fresh election then means as read together with all the electoral laws.
Right. Dr. Talala, what do judges have to consider this time round? And I mean, to the extent that they've already told us that, you know, an election should be conducted in strict conformity with the law, but given the realities of the Kenyan political situation, which has probably played out more now after, you know, the annulment of the first election, what would be their consideration practically in terms of, you know, upholding the law, but I suppose at the same time upholding the country?
I understand your difficulty in bringing that point across.
Even phrasing the question, exactly. Right.
If you ask me, I don't envy the justices for one or two reasons. Number one hoped that after dispensing with the first petition, the matters would be brought to rest and the country would move on. To see again an avalanche of applications, really, this time there are two. In fact, they were anticipated to be more than two.
Right.
Is not a pleasant thing at all for the justice. But my take is this, Anne, that the justices will be guided by nothing other than the law. Because the Elections Act, the Constitution, and what my brother here refers to Article 138, specifically 2, behoves the elections to be held in strict conformity, compliance, and concurrence with the law, which is the Constitution, and the election laws. Beyond that, the court, yes, may take into consideration, for example, if you look at the application by the Njonjo Mue team, where they cite the failure for the IBC to hold elections in the 290 constituencies, yes, the court may be invited to inquire into the reasons and circumstances that led to the elections not being held in those 290 constituencies. That may be a point of interest for the court. And if that be the point of interest, then the question that they'll be asking is, did the IBC properly apply the provisions of Section 55B, which give the IBC the mandate to cancel, to call off, to postpone elections in areas that peace is threatened. So in my view, that may be a point for the courts to consider. But overall, for the benefit of our viewers, without going to too much legalese, the court will be guided purely by the laws, that is the Constitution on one hand, and the applicable laws, which are the election laws. After all, that is what the justices ordered.
Right. James, we have now the election amendments in place as law,
yes.
The ones that Jubilee sponsored, and there has been debate surrounding whether this change of the legal regime will affect what the judges will be considering, you know, as soon as court is in session. Can the law now, in terms of the amendments, act retrospectively to the extent that this fresh presidential election was not carried out while these laws are in place, but again it is being petitioned now under a new legal regime?
The answer is no, and for our viewers, and the simple reason is this: the place to find the necessary guidance is Article 115 of the Constitution. This is what it says, that whenever a bill has been passed by Parliament into law, the relevant Speaker of the House will send it to the President for assent within 7 days, and the President is supposed to assent to it within 14 days, a failure of which he is supposed to send it back to Parliament with reservations or with comments. Now, if the President doesn't do that, under Article 115, sub-Article 6 or 5, I believe, then what should happen basically is that at the expiry of the 14 days, the law becomes law anyway, or the bill becomes an act of Parliament for the purposes of the Constitution anyway. Now, what is important for our viewers in as far as the Election Law Amendment Act is concerned, this is Amendment Act, I think, number 39 of 2017, is that this particular act is not law yet, because it has not acquired the force of law. Why? Because under that same article, an act of Parliament such as that is supposed to be gazetted for it to become an act of Parliament. And since it was gazetted, the 14 days that are required for it to become law have not lapsed. So for the purposes of this discussion, these petitions that we have seen being filed at the Supreme Court cannot be brought under or cannot be affected by the Election Laws Amendment Act of 2016 as envisaged in the amendments that we have mentioned.
Would the commencement date of such a law also affect whether or not it can be considered possibly if we face another annulment in the possibility of a fresh election?
Absolutely. If under Article 140 of the Constitution, the Supreme Court were to consider these petitions and annul the election once again, if this country is called again to conduct another election within another 60 days, then most definitely those particular laws are going to be part of the electoral process as we go forward.
I think, and just to clarify, if I got your question right, you are wondering whether these particular applications will be considered in view of the newly amended laws, if I got you right. The answer is no. Because the laws are gazetted as we speak. They have the 14 days, as Wakili says. However, for purposes of these applications, the elections were held under the previous law. And therefore, the operative law for the purpose of this application ought to be the law under which the elections were held. And that is not the Elections Amendment Law.
All right. Let's cross over now to the Supreme Court. Francis Gashuri, clearly you're burning the midnight oil for us. Thank you so much for that. Just moments ago, we saw, of course, the filing of this fresh petition with a pretty much upbeat Harun Dubi, who seems to be leading the legal team there at the courts. What can you tell us about the mood of counsel? Remember, of course, the last time they attempted to appear before these courts, their application was basically dead in the water on account of a quorum hitch. How are they this evening?
And clearly I'm on the night shift and enjoying it. And yes, the second petition, as it were, being filed by Helef Khalifa and Njonjo Mue, not yet still accepted by the Supreme Court per se, but documents are still continue to be filed. I saw a short while ago Julie Soweto, one of the lawyers representing the petitioners. They tell us that they have gone to make some final touches on the petition. More and more bundles of documents being made here. And Harun Dubi, a short while ago, came with many more bundles, and he tells me that he has to rush again to go and prepare more. Harun, quickly, what are your prayers? What is remaining? Has your petition been accepted formally by the Supreme Court?
The petition has been assessed, indeed, and what we are doing right now as we speak, my colleague and the petitioner Njonjo Mue and Julie Soweto are paying the money in the bank as we speak. So basically, the petition has been filed. One would say yes.
What are your prayers? What are the specifics of the prayers in a nutshell?
In a nutshell, we are seeking the invalidation of the fresh presidential election that was held on 26th of October this year on account, among other things, that it was an illegal, null and void process. It disenfranchised a lot of Kenyans. It took away the right of citizens, or rather, voters, to vote effectively, so that a government cannot obtain consent when of the people to govern them when the vote does not seem to count, and effectively that's what we are asking for, that election be nullified for the reason that there were illegalities and irregularities that were committed by a very partial commission, a confused commission, incompetent commission. The National Returning Officer, the chairperson of the IEBC, who is our first respondent, declared publicly that the commission was taking decisions without following the rules of natural justice and fairness and the rule of law, and that we have the view that the commission as a panel may have overstepped or overreached their mandate in terms of the conduct of the presidential election, because that really ought to have been managed specifically by the National Returning Officer.
Do I hear you talk about the 25 constituencies that did not conduct this election in 4 counties and the issues, the reasons that were being raised by IEBC on security matters?
That's one of them, but if you look across the country, really, the percentage of the country that there was a kind of a decent turnout was very small, possibly 13 or 10% of the country. So really, the entire country did not have a credible election. That's what we are saying.
One of the prayers I see is the question of the constitutionality of the Election Laws Amendment Act that was passed by Parliament and automatically became law, even though the President did not sign it into law. What are your specifics? Does it, as it were, complicate the petition that you're filing now compared to what was filed in August?
Under the law, that those amendments do not affect this petition. They don't affect that election because it is it's a principle in law that law cannot be retrospective or retroactive. So that when it was being passed, a lot of people, including those who passed it, the members of Parliament, might have been assuming that it would have to affect this election, that election, or the petition following subsequently. But it is that confusion we would like the court to pronounce itself, even making the very simple argument and point that law cannot affect this election because it was a continuation of a previous election which was nullified.
Lastly, I see you've listed NASA as one of the respondents in this matter. Why?
Because NASA created an environment that was not conducive for carrying out a free, fair and credible election in terms of either the violence that we saw on account of the protest that they called, or the fact that they even called for a boycott. Not that they were wrong to call for the boycott in terms of the constitutional right, but the point we're making is that they created an environment that wasn't conducive at all for an election. So that's why we're asking that election be nullified.
Thank you very much. And yes, clearly, Anna, you see, those are some of the grounds that are being raised by the petitioners in this case. We wait to see whether they will still be able to pay the 1.5 million shillings required to file this petition as security fee in time for the deadline for filing the presidential election petitions. And yes, we'll continue to stay here until we see the stamp from the registry of the Supreme Court that petition has been accepted or rejected. Back to you, Anne.
Thanks, Gashuria. Good sport, working the late shift for us this evening. All right, back to my panel now with Dr. Lutalala Muhana and James Mamboleo. Let's just talk about that, enjoining of, or citing rather, of NASA in terms of they possibly created an environment that made it impossible to have this election across the country. And prior to the filing of these petitions, what we have heard argued by the political class is this, that you cannot create a crisis and then benefit from it before the courts. And so their argument has been NASA created a political crisis by stopping IEBC from doing its job across the country and therefore cannot be beneficiaries of the same. How would a court of law interpret that?
You see, if it was NASA who had filed this petition, then your analogy would work straight. That, look, you cannot come here and complain that the elections are not free, fair, free of intimidation, free of violence, yet you are the authors of the same violence. However, the petitioners here are different. And therefore, that analogy may not work straight. However, I'm a bit bemused by the inclusion of NASA's respondents, because that could work as a double-edged sword. One, yes, the petitioners are pushing the argument that, look, one of the reasons why these elections are not free, fair and free from violence per the provisions of the law are that there were chaos which were clearly authored by NASA. And on the basis of that, they want the court to find that therefore those elections are not free and fair. It is not so much an indictment on NASA in that sense. They are simply saying that, look, these NASA guys actually brought this chaos, for lack of a better description. And therefore, that is a testimony that the elections were marred by violence, were marred by intimidation, and therefore they cannot qualify the test of a free and fair elections. The other side of the sword, why I say that it could just end up being a double-edged sword, is that by citing NASA as respondent, that could just give them a platform also to make their arguments for which they find that the election was not free and fair. Because really, it will be NASA's interest that the elections are nullified. That's what I've been complaining about. So whereas Council Ndubi's intention is not to have NASA having a platform to which they can propagate their views to bring down the election, it could just end up being a platform for NASA to do that, my views.
James, there's a petitioner who has filed an application before JSC saying that the current Supreme Court bench as constituted is unfit to hear and determine presidential election on the basis of meeting the constitutional threshold and the technicality, of requiring that odd number. Is this going to be a critical petition in regard to whether this case is actually kick off proper?
I do not think so, and the simple reason is this. There's a clear process in the Constitution that guides the removal or the suspension of a judge from office, and I don't see that that has actually been fulfilled. Under Article 168 of the Constitution, a judge can only be suspended or removed from office on the basis of such issues like incompetence, probably gross misconduct, the breach of a code of conduct that is laid down for judges, or for grossly misconducting themselves in a manner that probably violates the Constitution and the law. So what happens when such kind of allegations are made? The only place an allegation such as this can be made to and make sense is to the Judicial Service Commission. Once it's been made to the Judicial Service Commission, then the Judicial Service Commission evaluates that allegation and determines whether any of those grounds under Article 168 have actually been fulfilled. And if it finds that that is the case, then it presents that petition to the President, who either suspends the judge and then appoints a tribunal to evaluate or to investigate into that particular question.
But if memory serves me right, this one is not even on the question of conduct, but more so because we have one judge, Justice Ibrahim, who has been unwell, and we saw him not even live through the entire sittings of the previous petition, and so they're envisaging a situation where he will not be able to be part of this fresh sittings, and then you end up with an even number. So how does
that is not a problem at all.
Make the decision.
Because the Supreme Court is properly constituted if it has 5 judges. So the quorum is 5 judges. They can decide to sit as 5 or as 7. They don't have to sit as 6 for that particular purpose. And the kind of petitions that we have seen to the Judicial Service Commission have not precipitated that scenario that would lead any of the 2 to be disqualified from sitting as judges of the Supreme Court. So as far as we are concerned, for the purposes of these petitions, I think the court can guide itself properly by sitting as 5 judges, as an odd number instead of sitting as 6.
And what decision, I mean, how would you decide who doesn't sit to arrive at the 5?
I mean, that's something they can decide to agree amongst themselves. They don't have to use any particular, they don't have to tell us what particular method they use to reach that particular decision, so long as they are in compliance with the Constitution, which requires that they can sit as an odd number of 5 or 7. They will be properly constituted.
Dr. Moana?
Well, nothing much to add. I was not getting quite right what your question was about. I think what that position could be is about, if there are 6, are they properly constituted? And my brother has answered adequately. The quorum is 5. So as long as there are 5, the court is properly constituted. The worry is that if there are 6, what happens if there is a tie?
Exactly.
But I think that's something administrative which the Chief Justice in own wisdom ought to decide whether he can agree that one should step aside, we should only have 5 or just have 6. If there is a tie, then that is something they'll have to find out. So, but ideally it should be 5.
Something extremely important to add: whenever there is a tie, for instance, in the Supreme Court, then that means that the status quo remains. Which means that if you have made an application such as the ones that we have seen before the Supreme Court, that would mean that those applications would amount to nothing.
Okay.
Absolutely.
Interesting pointer. So, gentlemen, just about under a minute to go, and I'll allow you both 30 seconds of your final thoughts. So what will you be looking out for in this fresh, presidential petition battle? You can defer to senior, whoever is senior amongst you.
He's senior.
Okay.
Well, Anne, for me, this is a very interesting moment in our judicial history. This is the second time that the presidential election is going back to the Supreme Court. As a lawyer, it's interesting because there's a lot of gaps that were missing. There were a lot of gaps. For example, the very crux of Harun Mwau's petition, that the court ordered the election should be held afresh. And that's where the Constitution ends. This will offer us an opportunity for the Supreme Court now to lay the situation bare and say a fresh election would mean that we shall have nominations afresh, or that we shall proceed from where we stopped. So for me as a lawyer, it's an exciting moment through which a lot of gaps that have been there will be sealed, and great jurisprudence as far as the elections in this country is concerned. However, as far as the country is concerned, I can only appeal to calm among our citizenry, let the law take its course. But as I've always said, this country is one, we remain as one, and we have to remain patient as we go through the motions of the legalities.
James.
And you will notice that this constitution is about 7 years old. That's not a very old constitution. And one of the issues it deals with is a very hotly contested election, such as the one that we've gone through. You saw an election petition in 2013 in which the court tried to explain itself on a number of issues. And one of the big issues there has always been that question of a fresh election. That fresh election, as described in that particular decision, has been discussed severally, with reference now being made to the High Court for a determination as to what it could actually mean. And so for me as a lawyer also, I see this as a good opportunity to put that matter finally to rest. What does this fresh election actually entail? Who is supposed to participate in it? So that we do not have a situation in which people are running helter-skelter trying to understand what it actually portends for them every time the court says that you are now required to conduct an election every 60 days. This will be important for planning purposes for the IEBC. It's going to be important for planning purposes for political parties and for all people or lawyers, for all participants in elections, candidates and so on. And then most importantly, I think it is going to mark it's going to give some closure on some questions which have been left hanging for a long time. And this is going to be, I think, that place where the country probably will start healing and start seeing meaning in the electoral process as is portended by our laws. I see this as an opportunity by the Supreme Court to finally stamp its authority and say this is really what the electoral process means, and this is where it must end as far as Article 140 petitions are concerned.
I thank you both for your views, Dr. Lutalala Mukhwana and James Mamboleo, both advocates for being with us on this another historic day in Kenya's election history. I am Ann Kiguta. Thank you for watching, and of course you can count on Citizen TV for all your petition news. But for us right now, it's good night. God bless. Take care.